Good morning, ma'am. Are you Ashley Broussard?
Yes, ma'am.
And Ms. Broussard, in cause number 25 DCCR 0175, you're charged with the third-degree felony offense of injury to a child from October 28th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Also, I'm sure Mr. Kimler went over with you that that type of probation, if you're successful, means you don't have a felony conviction on your record. Do you understand? You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. I also want to make sure, Ms. Broussard, that you understand that after today, I will not accept this plea agreement. If you change your mind to want to plead guilty, you can plead open to the court. It could be to some different agreement, but it won't be this one unless there's some new information that your attorney or Mr. Smith gets between now and trial. Do you understand? All right, then I'll get it set on the trial docket, and Mr. Kimler will begin preparation for trial. You're free to go.
All right, stop right there because this is one of those courtroom moments that sounds routine, but it's a huge fork in the road. The judge is making sure Ashley understands the gamble. She's charged with injury to a child, a third-degree felony, and if she goes to trial and loses, she's looking at 2 to 10 years. The DA offered a 5-year deferred probation plus a $500 fine, and the upside of deferred is big. If she completes it successfully, she avoids having a felony conviction on her record. But here's the key warning. The judge slips in like a trapdoor. After today, that offer is off the table. If she changes her mind later, she can still plead just open to the court, meaning the judge can sentence anywhere in the range. So what do you think? Would you roll the dice on trial or take the deferred DO and protect your record?
Yeah. Mr. Kimler, you filed a motion about bond conditions.
And there was an interval between the events made the basis of this case and the arrest, I think 3 or 4 months, rather long, when CPS was investigating the case where she had custody of the child, or at least was visiting the child.
What?
With CPS.
Y'all can't both talk at the same time.
With CPS supervision without any problems. Then when she was arrested, there was a condition of bond that she not have any contact with the child. CPS doesn't have any issues with her having visitation or contact with the child. We were just asking the court remove that bond condition because it's impacting her relationship with the child. And I think the child's development. How old's the child? 3 years old.
Give me just a second. Can you hand me that I'm printing, please?
Who was the CPS investigator? If you have any questions for her, we can run it over.
Mr. Smith?
If Mr. Smith has any questions, run it over.
No, I'm asking what your position is.
It's opposed, Judge. And again, I would just observe that there was about approximately 4-month period prior to her arrest. There were no incidents.
But that was...
There's a co-defendant in this case, Dalvius Williams. We had a hearing on this. I believe it's an MTRP on Mr. Williams. So you've seen the evidence in this case. I don't know if you recall it, but the child was 2 years old and nonverbal. Showed up at school Friday, everything was fine. Shows back up, misses Monday, shows back up Tuesday. The marks are there, and allegations are that those were the only people around her at the time.
And I would just observe that there was a CPS investigation subsequent to that where the child remained in contact with the defendant with no deleterious consequences reported.
No, what consequences?
Bad consequences.
No,
Harmful.
what's your word?
Deleterious.
It's not going to be my word of the day to learn.
It's one of those SAT vocabulary.
Mm-hmm. It's been a long time since I took that. I'm trying to recall that hearing. I feel like that Mr. Williams was maybe more culpable with regard to the specific allegations, not necessarily not turn them in and things like that, but the actual physical.
And then when the police started the investigation on this, she lied to the police.
Allegedly, she didn't cooperate. We can agree on that. It was non-cooperative.
The only thing I will do, I will modify the bond condition that you can have contact with the child, but it is only to be supervised. So you are never to be alone with the child, period.
Is that through CPS supervision or who's the supervision?
I don't, if CPS isn't involved, I can't order them to supervise. So y'all work on figuring that out, but there has to be another adult, of some adult at all times, not a 16-year-old, an 18-year-old, someone. Okay, perfect. Then I'll let you have visitation so that you can, obviously, I think this is something you will be able to get past. You'll be able to hopefully work towards more than just this, but I want to start off with me feeling comfortable with that until we figure out what's going on in your case.
Just
Okay.
in the interest of specificity, she's only to have contact with the child in presence of the grandmother. What's the grandmother's name?
Dana Williams.
She's
Okay.
only to have contact with the child in the presence of Dana Williams.
Okay, yes, that's the order. Thank you, Mr. Kimmler. Yeah, probably so. All right, sir, you're Michael Brasher.
Yes, ma'am.
And Mr. Brasher's case is set for trial to begin with jury selection on June 23rd. Obviously, Mr. Brasher, you were in custody last time you were here, and now you've made bond. And since you've made bond, I hate to move, your case is getting old, but if you've made bond, I expect you to try to hire a lawyer.
That is exactly what I brought here I brought some paperwork to present to the court if you see it. I want to ask for a continuance for that same reason.
So here's what I'm going to do, Mr. Brasher. I'm going to take your case off the trial docket and move it to a designation docket. I'm going to reset it about 30 days. You need to try to get someone hired before that court date.
Okay.
If you do, we'll give you a written reset notice today. Make sure you bring that to whoever you hire and they'll tell you what to do.
Okay.
If for some reason you cannot hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
I have an attorney. I've spoken with him. He's given me a quoted amount. That's why I brought some of this stuff
Okay.
to show you.
I don't necessarily need to see it. I just need to, I'm going to see what you can do in the next 30 days. If for some reason, and I know you just bonded out, so if you possibly need more time, I understand. When you come back, let me know. If you haven't hired him or anyone else, make sure you visit with plenty of attorneys, bring me those names, or if you have one picked, have that information. If you've made payments, bring me that information, and then we'll discuss your options, okay?
I can absolutely. Would you like his name now? Or?
Who is it? Yeah.
Mark Gonzalez of Corpus Christi.
Okay. All right. Then make sure also that if that's who you hired, that Mr. Gonzalez knows that your case is old and that we will expect whoever you hire. Hold on a second while I'm talking, please, Mr. Majid. That's okay. Make sure whoever you hire understands that your case, if it's not worked out, is going to be set for trial pretty quickly because it's old. And so a lot of attorneys think they're going to get on and they'll have plenty of time. It's not going to be like that. They're going to get pushed. So you be sure and tell them that, okay?
And yes, ma'am. We've talked about that too.
Okay,
So,
perfect.
He understands that as well.
Okay, if you'll step over here in front of the clerk, she'll give you that reset notice. Thank you. And also, until then, Mr. Matusky, you're obviously still on the case, begin to prepare possibly for trial, but I will take it off the trial docket at this point, just to give Mr. Brasher some time.
Yes, ma'am.
All right.
Thank you, Judge.
Yes, sir. So we need Mr. Jeffries again, I guess, at some point. Oh, I don't have all that yet. Y'all hold on just a second. Good morning, ma'am. You're Renisha Payan? And will your client waive the formal reading of the indictment?
So
Ms. Payan, in cause number 24, DCCR 2107, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from August 25th of 2024. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? Speak up.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
Yes.
Do you fully understand them? And it's my understanding that you are pleading guilty open to the court, which means I can sentence you anywhere in the range of punishment. Is that your understanding?
Yes, ma'am.
So y'all signed the post-conviction waivers
Oh, I'm sorry.
on the
Sure.
admonishments,
I should-
but
Well,
y'all didn't sign them on the, you said it wasn't an agree.
I don't even know, is she waiving post-conviction waivers if it's an open plea? I mean, after she's sentenced, if she gets
She-
probation, she could waive them then.
You're the one who marked them. No, she can't.
That's what I'm saying. Okay, I'm sorry.
That's why I'm bringing it up.
All right.
Y'all marked that it was a plea bargain, everything is all marked
Yeah, I should've-
incorrectly.
I shouldn't have had her sign the post-conviction. waivers.
Okay.
I'm sorry. It's forced to have it, Your Honor.
And then on that last page, I changed it with everyone's permission to the fact that it's not a plea agreement on the certification of right to appeal.
Right.
Okay. And I'll mark through. Okay. Okay, so I want to make sure you understand, you have an absolute, so first of all, I can sentence you anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. I can consider probation. It'll all depend on information that's brought to me when we come back for sentencing. You have an absolute right to have a jury, which you're set for trial next week, starting trial on Monday, and let that jury decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, then you're waiving that. And is that what you want to do? Okay. State, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Payan is not competent?
There's no.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimmler. He will present it to me on your behalf when we come back.
Yes.
All right, you can, on your way out of the courtroom, stop and talk to probation. She's at that desk right there. Okay?
Discovery, right?
Yeah, discovery.
Because we just watched 3 very different courtroom decisions with one common theme. First, Ashley Broussard rejects a negotiated offer on an injury. To a child case, she's told clearly the trial risk is 2 to 10 years, and the rejected offer was 5 years, deferred probation plus a $500 fine. With the major benefit that successful deferred can avoid a felony conviction. The state opposes removing the no contact condition. Next, Michael Brasher gets his trial date moved to a designation docket. He has about 30 days to hire counsel or show effort by meeting at least 3 lawyers, because the court says the case is old and could move fast. Meaning sentencing is wide open in the 2 to 10 year range. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.